welcome to the seminar series. This is our 5th week in competition law seminars. As usual, we have 2 topics today. And the first topic, the both topics they concern digital markets. In the first one, where we have, it's hard to pronounce your name,
Evgeny.
Evgeny, will be presented by Evgeny, and the topic basically concerns the institutional design, how to deal with the problems of digital markets. As you might remember, during our previous sessions, we already discussed about the particular problems or peculiar problems related to digital markets and network externalities, economies of scale, economies of scope, and some other factors result in some sort of market failure in digital markets. And we have been discussing whether or not competition law was a useful tool to deal with these problems. And in some of our previous presentations, we also discussed about the DMA and German model. And today we have a very similar topic, and I think they are complementary in that regard. Evgeny will discuss the proper institutional design in dealing with the problems of digital markets. So he will discuss first competition law, then regulation, DMA type regulation, and then targeted design, targeted regulation, where I think some sort of a prohibition of particular behavior, right? We can call it like that, like for example, most favored nation clause. And fourth, I think, which is interesting for me, is it's a self-regulation or soft regulation designs, where I think they have used in Russia and some countries as well. So very interesting topic. I think that you will find it useful as well. But before that, I will introduce, before giving him the floor, I will introduce Evgeny. And I need my glasses. That. Okay, Evgeny Khokhlov'un is a partner at Antitrust Advisory. This is a firm dealing with specifically competition law litigation and all sorts of competition law matters. He's a member of the FAS of the Russian Council on IT sector and the Council on Foreign Investment, and a member of the Russian Association of Competition Experts. In 2008 and 2011, Evgeny was awarded a certificate of merit by the FAS of Russia. FAS is the competition authority in Russia. In 2015, he was awarded a second-class medal of the Order of Merit for services to Russia in contributing to the advancement of antitrust regulation in the country. Evgeny is a lecturer in competition law at the Kutafin Moscow State Law University. So I would like to thank Evgeny for first applying to our program because his paper or his abstract was basically selected by the jury. And I'd like to thank him for this application. And plus, I'd like to thank him for coming here and being together with us. He came all the way from the Moscow. So the floor is yours. You have 40 minutes. Thank you.
Thank you. Thanks for the introduction and for having me here. It's a very interesting initiative that we have. I mean, inviting lawyers and economists from different countries to talk about competition law, even though enforcement is national, local, the issues that we face are truly global, and many other countries have faced similar problems, especially in the digital sphere. So I guess it's a very good initiative, and thanks for inviting me here. I started dealing with digital markets since 2012. It's almost 15 years, and I started doing these cases when it wasn't that popular. And what should I say? The issues that we faced back then are pretty much the same as we're facing now. Not so many things changed since then. The issues are still there. So, as you rightly mentioned, my topic today is to compare different tools, different options in dealing with digital markets. And we'll start with Larry Page, who was Google's ex-CEO, and his famous saying, "Competition is one click away." It's so untrue. Competition is not one click away in digital markets. There are lots of features that make competition quite difficult to achieve in digital markets. And he said those words, I think, more than 15 or probably more years ago. But Google and some other big tech companies are still there with just a few examples of disruptors which prove the same notion that competition is not one click away. As I understand, you have already discussed what makes digital markets so special. I will not stop here for a long time, but just to make a general overview is that classical antitrust regulation was formed obviously based on traditional markets, based on physical products, and digital markets, they are quite specific. And there was a debate as to whether antitrust enforcement is in principle applicable to digital markets. And I think this debate has ended by a general perception that antitrust regulation should apply to digital markets with certain specifics. And lots of countries have already dealt with antitrust investigations in digital markets. I will talk about it in a few minutes. And I have summarized a number of theories of harm, a number of anti-competitive practices that digital markets conduct, which they were investigated about. And as you can see, the theories of harm are pretty much traditional when it comes to antitrust. So preferential treatment, parity clauses, high fees, bundling, all these kinds of things are being done not only by digital companies. But there are also some novel theories of harm developed in the digital area. And it's a mixture, to me, it's a mixture between wider policy goals and competition goals. And this is something that is debated right now as to whether competition law should, in principle, be involved in those kinds of theories of harms. And then the question is, if digital markets are subject to anti-competitive behavior, how to combat this kind of behavior, because digital markets have become very important for consumers, for economies in the majority of countries. And I think 4 options have been developed globally, and you mentioned all of them. So we will touch upon each one of them and try to find pros and cons of each of the options. So we'll start with classical antitrust regulation. It has been pursued through antitrust investigations, and many digital companies have already faced those investigations in many countries across the world. Again, I've summarized some common anti-competitive practices by global tech companies and provided just a few examples, but there are much more cases than that. I will not touch upon it in detail because I believe you will hear about those cases in other presentations. And Turkey is not far from that. I would say that Turkey is one of the countries, one of the few countries that actively pursues antitrust cases against tech companies. I listed just a few examples, and there are more cases currently ongoing as well. So it is fair to say that Turkey is using antitrust regulation as the key option to tackle anti-competitive practices against tech companies. So here is the flow. Here are the elements of any antitrust investigation. As you can see, there are lots of elements. I'm pretty sure you are familiar with them. The point is that antitrust investigations involve very difficult issues to deal with. And I will illustrate that starting with the market definition. And the question is as to whether market definition is really necessary. Obviously, it's a common ground that each and every antitrust investigation should start with market definition. It is important just to set the scene and understand what markets we're talking about. But is it really important? And it's a good question specifically for digital market, because there are lots of specifics that make market definition very difficult for digital markets. And it is currently being debated in different countries as to whether we should avoid market definition altogether. But I should say I have not seen any case, even in the US, even in the EU, obviously, elsewhere, where market definition wasn't followed. So it's still a theoretical discussion. And just to illustrate the difficulties with the market definition, two cases that I wanted to compare. So there is a long-standing view that iOS and Android operating systems are separate markets, even though Apple and Google are arguing that they're competing between each other. But when it comes to other types of services like video hosting, like social networks, there is recent case law suggesting that they are substitutes, like YouTube and Facebook. So another element to an antitrust investigation is not only to do market definition, but also to calculate market shares, because the market share is still a sign of potential market power. And all the economic knowledge developed about markets was developed with respect to traditional markets. And it's quite easy to calculate market shares based on volume of supply. But the issue with digital markets is that the service of a digital platform itself does typically not have a cost, does typically not have fees, and it's difficult to calculate sales. And then there is a second distinction between transactional and non-transactional digital platforms. If a digital platform makes interaction between different kinds of users, different types of users, easier, then it is a transactional platform, and then it's natural to calculate market shares based on the value of transactions that were entered into with the use of that platform. But when it comes to non-transactional platforms like social networks, what should be the measure of the market, the measure of the market share? And it is still a debated question. For example, the most novel discussion is about time spent, because everyone understands that a general user doesn't have a lot of time to spend on digital platforms, probably 2 or 3, 4 hours a day. And if he or she spends time, more time on a specific platform, even though this platform is not similar to some other platforms, then it probably has market power because most of the user time is devoted to this platform. So it's still being discussed globally, and different competition authorities use different types of measures in respect of non-transactional platforms. And then there is another thing. There is a classical SNP test. I'm pretty sure you know what it is. But it is linked to a price. As I mentioned, many digital platforms lack direct price for the products they provide, and therefore SNP test is not really applicable. And it was proposed to substitute the SNP test with the SNC test, Q as in quality. The idea is that in the absence of a price, one of the other decisive factors is quality, and the question to be asked is if the quality is degraded by the platform, will users stay with it or switch to another platform? The idea is good, but the problem with this test is that it is kind of subjective. I found an example where this test was actually applied in a case. It was the same case I mentioned against Meta. It was not the only test used, but one of the tests. And I think the results are a little bit mixed, and to me, the test is still very subjective, because quality is a subjective criterion. There is no generic understanding of what is the best qualities. But still, there is a practical example of the test applied. And then there are also difficulties in demonstrating the theories of harm. And digital platforms, they try to defend their behavior by using different arguments. One of the key arguments is that they use anti-competitive restrictive practices in order to maintain the whole of the ecosystem. And then the question is as to whether the users actually ask for an ecosystem to be in place, because it's currently is competition between ecosystems. It's true, but then the question is whether it's beneficial for users to have ecosystems, really. So it's a difficult question for competition authorities, and therefore some of them are more cautious when dealing with digital markets because they fear they could interfere with the ecosystem and just break it down. And tech companies are going into those arguments. For example, free riding argument, which wasn't used for many years, it is a typical defense argument in the tech cases. So there are lots of other issues with antitrust enforcement in digital markets, but there is one important element which I wanted to stress upon is the duration of antitrust investigations. So here is an example based on the Google Android case in the EU, which lasted for like 15 years, right? And until the last appeal, which is due to be delivered later this year by the Court of Justice. And there is even more illustrative example based on the Google shopping case again in the EU. And the interesting thing is that by the time when the Commission issued its decision, within more than 7 years from the start, the key complainants have ceased to exist. So the question is whether there is anyone left worth protecting because of this case. And what is the goal? Just to punish the company or restore competition? It's difficult to restore competition, really. So it's a common ground, especially in the EU and the US, that antitrust investigations take a very long time. As regards Turkey, we had a discussion just before the presentation that things are changing, that the competition authority have started to deal with digital cases a little bit faster than it used to. Yeah, so this slide illustrated the Google search case, which lasted for quite some time. But what I heard is that the competition authority is now doing things more promptly, which is a good thing to me.
Especially the commitment procedures, it's really fast.
Right. But it's still a problem for many countries. For example, in Latin America, like Brazil, investigations there could last more than 3 years and even longer. And we're talking about quite developed jurisdictions like the EU, the US. And if we are talking about less developed jurisdictions, which are not very familiar with digital markets, not to say antitrust investigations as a whole, the situation is not that good. So Turkey seems like a nice place to have to launch competition investigations against big tech. Yes, and big tech companies, they also are using various tricks to delay compliance. Again, the same thing was with Google in Turkey when Google didn't comply with the remedies order in the first place, and then the competition authority imposed periodic payments for the non-compliance, and then Google said they will completely withdraw the market because of that, but somehow they agreed between each other that Google should comply. So this illustrates the fact that tech companies are not very keen to comply with remedies. And here's another example. It's a prominent Epic Games case against Google in the US, which ended up with the settlement agreement, which is a good thing. But then it involves certain steps to be complied with. And as you can see, it will take at least 2 years for Google to fully comply with what the settlement provides. And then to the first point, competition is not one click away. If it was, then it wouldn't take 2 years for Google to comply with any of such remedies. So summarizing what I have discussed. So classical antitrust regulation has its obvious pros. Like everything in this world, it has pros and cons. So the key pros to me are that the practices of big tech are global in nature. They're not country-specific, or very rarely country-specific. And it means that any country could use the decisions, the approaches developed in other jurisdictions to combat anti-competitive practices. Also, antitrust regulation helps combat specific issues that raise concerns that are damaging to consumers and competitors. And another good thing is that competition authorities have the possibility of issuing remedies, which could not only, let's say, punish the offender, but also try and restore competition in the market, which is, I think, the key goal of any antitrust investigation. But classical antitrust regulation has its cons, which is the duration of investigations. It really takes a lot of time and effort and funding. Again, the practices are global, and it means if you want to combat a specific practice, you have to launch antitrust investigations in each and every country. There is no international competition law yet, and I don't think it ever will be. The risk of the non-compliance with remedies is also there, and Google's behavior is one of the examples. But also, given the dynamic nature of the markets, big tech has a lot of very minor tactics that could basically circumvent any remedy. So what are the alternatives to classical antitrust? And Sure.
There are pros and cons of antitrust enforcement in this market, and you summarize them very properly. But so, do you generally yourself, in your view, do you favor antitrust enforcement, or you're basically neutral to this?
Sure.
You favor antitrust enforcement?
I do. But we are skipping until the end of the presentation.
Right.
So there is a takeaway there. So I will tell about my view at the end, if that's okay. So a natural alternative is regulation, and when it comes to regulation versus antitrust, competition law specialists are very skeptical about regulation. If you talk to competition lawyers, they're saying no, regulation is bad, antitrust is good. But to me, it's not that predetermined. I mean, if something works better, then it should be applied, even though we all are in favor of antitrust. But within regulation, there are two types of regulation that I mentioned. One is, I'm calling it sector-specific regulation, meaning regulation specifically dedicated to the digital market as an industry. So it's applicable to all of the types, or many types of digital markets. And targeted regulation, which applies to specific issues in specific markets. So I will start with the statutory regulation, and obviously the two examples that are currently in force in the world are the DMA and DMCC in the UK, which is a similar concept to the DMA, although the burden is a little bit different, but the concept is pretty much the same. And what was the rationale behind the adoption of the DMA? So the idea was to try and resolve the existing difficulties in antitrust regulation in respect of digital markets. And the idea was to set some sort of ex ante regulation, as opposed to ex post regulation, which competition law is, meaning that it is easier to prevent something bad than to deal with the consequences. Again, one of the driving factors was the duration of investigations, and in Europe it's really crazy. It's like in the anecdote when a son comes to his father lawyer and says, "Father, I have very good news. I have won a case that you worked at for many years." And then the father says, "Oh, how stupid of you. This case could have provided for your children as well." So that is so true for antitrust investigations in general and in respect of digital markets in the EU specifically. So the idea was to set certain limitations to the procedure, certain a less elaborate procedure, let's say. And then there is also a good feature, is that regulation provides for greater certainty to undertakings, because antitrust regulation is quite unspecific in a way that sometimes certain types of behavior, it's not obvious that this type of behavior violates competition law. And it's understandable because you can't set the whole bunch of features in any law. But regulation makes rules more obvious for companies. So it's also a good feature. But then the question is, was the DMA really a swift response to the issues we discussed? And my opinion, no, it wasn't. Basically, the DMA created a parallel system which exists in addition to antitrust. And it doesn't resolve the key issues that are part of the antitrust discourse. So we have seen lots of non-compliance investigations opened by the Commission, and they are currently being reviewed, and then they will be obviously appealed to the courts. So it will involve the whole bunch of things that are currently there in respect of antitrust investigations. But still, it's a popular concept, and the DMA-like acts are discussed in various countries. So I've heard from you that Turkey is off the list discussing the DMA, but still it was a proposal some time ago. Actually, Brazil, most recently, I think a week ago, announced that they are developing something similar to the DMA. Some other countries are also discussing it. So it's a popular concept, but in my opinion, it's not really a workable concept. But it's my view only. I'm quite skeptical about it. So again, I will skip the pros because I actually discussed them. In terms of cons, sector-specific regulation should actually be aimed at a wider range of entities. Actually, DMA is a bad example because it's a common ground that there is a concept of gatekeepers there, which required to comply with the DMA requirements. And there is a common ground that the criteria for gatekeepers were developed in order to target the US corporations, and with just two exceptions. And there is a significant tension going on right now between the EU and the US because of that. It's actually a political question, and President Trump was also flagging this issue, and he's very unhappy about the DMA. So DMA is not a good example because it basically applies to quite specific companies, but overall the industry regulation should tackle a wider range of entities. Again, it's not a quick response in a way that the discussion of such significant piece of legislation takes time. It might not be even successful like in Turkey. And then, again, the problem is that the non-compliance is still possible. In the ideal world, obviously, all the companies will be compliant with legislation, but in the real world, non-compliance is an issue, and we will have to investigate it and impose remedies, etc. So it's, again, a lengthy time frame. So then we come to the targeted regulation, and the idea behind this is not to set out a list of requirements for the wider industry, but rather tackle quite specific issues in specific markets. And I have listed the examples. For example, the European countries have introduced the prohibition of parity clauses. It's one of the classical antitrust theories of harm, and in some of the countries, parity clauses are prohibited following the Book.com cases. In Russia, there is a set of rules requiring manufacturers to pre-install local apps and services on a wide range of devices. The idea behind this regulation is to help level the playing field between global players and local players, because what global players do, they pre-install their apps and services through platforms and then exploit what is called user bias. That is when users tend to use what is in easier reach, even though they can change settings, but most of the users don't do that, even though they prefer something else. So the idea is to have local apps pre-installed in addition, not in substitution, but in addition to global apps, so that local service providers can have access to platforms. And then there are some other countries, including China, very interesting examples of targeted regulation, and also Korea, which resolved the in-app payment issues through legislation as opposed to antitrust investigations. So obviously, there are pros to this, and the key pro is that this type of legislation allows to tackle specific problems that are not very easy to be resolved through antitrust regulation. The effect on the market participant is very specific, meaning that it doesn't apply to the market as a whole, but rather to specific companies. There is already experience in other countries, and I should say quite successful experience, at least based on my knowledge related to Russia and China. And this is a prompt measure, at least as opposed to classical antitrust regulation. But there are also cons to this. So there is no prevention mechanism, so it's a requirement to be fulfilled, but it doesn't prevent companies from trying to circumvent this or from applying other types of anti-competitive conduct. The problem also is with the dynamic nature of the digital markets, which are evolving very fast. And if you, for example, pre-installation is one of the options, but if something else is developed, then this legislation becomes useless. And there is also a risk of non-compliance. And the problem is that with this type of legislation, competition authorities are not typically dealing with it, and the supervision is typically levied on other regulators, which are not very familiar with digital markets, and it is quite uneasy to enforce those provisions. So there is the fourth option, which is self-regulation. What I mean by it is the rules and standards that are non-binding and that are developed by the market participants themselves. And this concept is becoming more and more frequently used across the globe, not only in the digital sector, but also in other sectors as well. It's called soft law as well. So there are two types of self-regulation, white book and black book. White book is the list of practices that are deemed fair, whereas black book is what is basically prohibited. And the difference between self-regulation and regulation is that regulation is a black book. I have not seen any legislation that is framed as a white book, whereas sometimes businesses are more interested in understanding what they can do as opposed to what they can't do. So self-regulation provides for that interesting option. I have listed a few examples of self-regulation that I have found, and I should say Russia is on the forefront with this. And the reason for that, I think, is because most of the Russian digital markets are very competitive. There isn't any clear monopolist in most of such markets, and the competition is quite fearsome. And therefore, lots of issues arise, and companies very often complain against each other, and the idea is that they should basically develop what are the best practices and follow them. I should just provide, I have other slides providing for more details about the acts of self-regulation in Russia. I will skip them. Will the presentation be available?
It is already available, I think.
Okay, so you can, if interested, you can look at this in more detail. But an example that is very fresh, just last Friday, there was a session at the Expert Council at the Russian Antitrust Authority that was discussing a very specific problem. So in the marketplace, so there are marketplaces in Russia, two significant ones and some smaller ones, and there is basically a price war between the large ones, which have resulted in very deep discounts to a wide range of products. And this practice is a good example of predatory pricing, obviously, because it is not beneficial for anyone. It's not beneficial for end customers because the idea is to try and squeeze smaller competitors out of the market. It's not beneficial for sellers who sell through marketplaces because they have to adhere to the same prices in all of the other channels, because otherwise customers will just buy through the marketplaces. And it's not good for competing marketplaces and other platforms because they do not have that kind of deep pockets to subsidize the discount. So the problem has come to a point when nobody knows what to do, and the resolution was to try a self-regulation. The idea was that the key platforms should set out transparent rules of providing discounts and to let sellers reject or opt out of a discount in case they want to. So the authority clearly stated that self-regulation is what they want to pursue because it's a very sensitive issue. But if self-regulation doesn't work, then they have no other choice than to start an investigation. So this is what is going on as we speak, let's say. So it's a big issue, and the belief is that it could be resolved through self-regulation. In addition to classical self-regulation, I also want to say a few words about settlement agreements. It's not self-regulation, obviously, because it's part of an antitrust investigation, but still this is something that is very close because settlement agreements are typically developed by the market participants themselves, and they have a lot of pros as opposed to classical remedies. There's just one example out of settlement agreements between the Russian Antitrust Authority and Google. It was in respect of the Android case, which was also pursued in the EU and Turkey and some other countries. And the remedy that was proposed on the basis of the settlement agreement was implemented the choice screen for the default search on the device. Again, the idea is to let users make a proactive choice of the default option, because otherwise users tend to use what is set as default, even though they can change the default setting, or they prefer something else. And this remedy have proven very effective. And my personal regret, is that no other competition authority have ever applied it, except for the Belarus Competition Authority, which was brave enough to apply it. This remedy was actually debated as part of the Google Android case in the US, but the judge specifically mentioned that he wouldn't apply this remedy. The reasoning wasn't very convincing to me. But then this remedy was possible only because of the settlement agreement, because the authority wasn't in favor of this remedy in the first place. So what are the pros of self-regulation? The key pro is that self-regulation is developed by the market participants themselves, meaning that they know the market better as opposed to regulators. Regulators are outsiders. They might not understand the issues to the same extent as undertakings. Self-regulation is actually faster than statutory regulation because, again, it's in the interest of the market participants to develop something that will basically be a substitute to statutory regulation. And the non-compliance risk is a little bit lower because the companies are generally interested in what they have written themselves. But there are obviously cons, meaning that there is no binding mechanism, and the regulation, self-regulation, is obviously non-mandatory. and the regulatory involvement is still needed because public interest should be fit into self-regulation. So the authorities are basically involved, even though it's self-regulation. And then another con is that undertakings are not very keen to address most serious issues. So they are trying to address less serious concerns, leaving more serious ones for antitrust investigations or statutory regulation. So, coming back to your question, I think the proper way to regulate digital markets is through a combination of antitrust enforcement, targeted regulation, self-regulation. I'm not a believer into the DMA type regulation for the reasons I mentioned. So I think everything has its pros and cons, right? So the authorities and other stakeholders should use specific tools when it comes to specific problems. That's the key point and the key takeaway.
Well, thank you very much, Evgeny, for the presentation. I have some questions, but let me turn to the floor and ask whether you have any questions. All right.
Thank you for your presentation. In China, there is a new changes in the competition law, and there's an advantageous position in guidelines. And in Turkey, actually, we have some sort of similar position in our electronic trade law. So, what your take on this topic? Advantageous position is much more feasible for digital markets because it's not treated as the dominant position, but it's also have some sort of legal certainty. I want to hear your thoughts about it. Thank you very much.
Thanks. That's actually a very good question because it's a concept that was developed in France, I think, and Italy. It's like superior bargaining power kind of concept, meaning that it's not equal to dominance, but it means with respect to a specific customer or a specific type of customer, this particular undertaking has superior bargaining power. So it might not have it for the whole of the markets or for all of the customers, but with respect to specific dealing partners, it has this kind of power. And this has initially been developed for retail chains. Right. Right. It has been pursued, this concept in various countries, in the UK, in Uzbekistan, in some other countries, but it doesn't really a public interest thing to me. So to me, it's more like a civil law concept, meaning that if it's like protection of consumers. So if it's the same ideology. So there is a smaller business, a smaller undertaking, which should have some defense from the government, from the courts. So to me, it's not an abstract concept. It should be applied separately as part of the disputes between contracting parties. That's my take.
Thank you very much for the question and answer.
Thank you for presentation. I have a quick question. Same London financial street managed by financial company. So it's a good question. A good example for self-regulation is another thing. Thank you.
So the question is about fintech. Yes, fintech is obviously one of the novel areas, and regulation is not very fast in this area. So self-regulation comes like a temporary solution in many respects. So yes, it's a good example of self-regulation. Fintech is a good example.
Do we have a self-regulation in Turkish law? Do you remember any? When we say self-regulation, as Evgeny described, anything come to your mind? I mean, we don't have it in competition law that we can say, We had a discussion after 2011. What report? The retail report for fast moving goods, and then after the report basically ended up with an offer of, we can utilize this way of dealing with the problem, but nothing happened after that. No. That's regulation. That's regulation. I mean, we have not discussed with him, and perhaps I should have informed him that we have a DMA type, quasi-type regulation in Turkey, which has a limited scope, just for the retail marketplaces, and that's very unique to Turkish case. But it's not soft law. It's really a hardcore law. I mean. All right, you have a question?
No, I don't have a question. I just want to give an example regarding self-regulation. We have actually one sorry? No, not corporate governance, for advertising law. No, not for competition. Also, there is a board which we call self-regulation advertising board. Yeah.
Useful information. Thank you very much. All right. You have a questions now?
Thank you very much for the excellent presentation. I was interested in the points regarding targeted regulation. So one thing I thought when I saw the examples, particularly from Russia and Poland, I mean, in this case, I think we are looking at regulations that come directly from the political branch. So in these cases, is there a greater risk that considerations other than purely competition, more political considerations, such as, for example, protectionism, will creep into that regulation? Because when I saw the regulations being specifically framed for domestic products, it seemed more, I mean, I'm sure it serves the competition law interest as well, since the dominant platforms are usually foreign, but it could also be read in a protectionist manner. And I think our e-commerce law is kind of an example of that as well. You can really see effects of certain lobbying efforts in parts of the law. So, if you leave it directly to the legislature, to the political branch too much, for them to get directly involved in a targeted manner, are you taking perhaps other risks?
Yeah, I agree with you. I have listed only those examples that deal with competition problems. Obviously, lots of countries impose protectionist legislation when it comes to digital industry, lots of personal law, personal data requirements, onshoring requirements, etc., etc. So I was talking about only the market failures that are being dealt with the targeted regulation. And the reasoning for this is the same as, so basically this legislation in Russia, it came out of the Android case. But the Android case was limited to search and all of that, whereas this legislation relates to a wider range of services and a wider range of devices. And again, the idea is not only protectionist, the idea is to promote competition. Obviously, it's protectionist, yes, but the interest of any country is to protect its own companies, right? It's natural.
Thank you for the question and answer. Any other question we have here? Okay, one more.
Thank you for your presentation. It's just, maybe it's a very strange topic for me, this self-regulation thing, and I couldn't comprehend that why would any stakeholder be willing to limit their actions, their activities voluntarily? What's in it for them? Yeah, what's the motivation?
Well, the reasoning is it is sometimes preferential that they frame the rules as opposed to regulators, because the fear is that the regulators will do something more severe, more harsh, or wrong. So if a clear issue arises in the markets, if there is a deficit, a clear one, then the industry market participants understand that it will be resolved one way or another. through antitrust regulation or statutory regulation, and self-regulation seems like a better option to them.
So basically, they avoid drastic, interference with the marketplace, and that's their interest.
Exactly.
Do we have another question? All right, I think one final thing. When I was thinking about this, soft law or self-regulation, perhaps the commitment procedures that we have in Turkish law might have similar characteristics. I mean, of course, they are applied in the shadow of, monetary fines and, of course, other drastic remedies, but still, they look like some sort of, since there's this sort of consent with the authority and with the stakeholders, there are some similar characteristics of that, but they are not, soft law per se. So that was my point. Well, thank you very much for the presentation. Thank you for the questions and answers. Thank you.